Good morning, everyone. This is a session on futures planning, special needs trusts, and ABLE. And we're recording it with the ARC of Greater Prince William County with an address in the chat box. If you have any questions or technical issues, you can contact them now. Next slide. I guess I'm on control of the slides myself. This is me. I'm the Director of Trusts at the ARC of Northern Virginia. I've been there now for 15 years and in the position of Director of Trusts since August of 2009 when the position was actually created. For those of you that don't know the ARC is a national organization with about 660 chapters nationwide and a mission to promote and protect the human rights of people with intellectual and developmental disabilities and actively support their full inclusion and participation in the community throughout their lifetimes. We also have core principles and core values that are listed on the ARC National's website. I am at a local chapter, the ARC of Northern Virginia. So the ARC of Greater Prince William and ARC of Northern Virginia are sister chapters. We have 23 chapters in Virginia. We're a fairly active Commonwealth with advocacy efforts both at local, state, and national levels. And all of our chapters are funded through some direct services that we provide, but also supported by membership dues and donations. Our Special Needs Trust Program has been at the ARC for over 20 years. Our primary region is Virginia, Maryland, and Washington, D.C., although we do have trusts set up in other parts of the United States. So people may have moved out of state and wanted to maintain the trust with us, which is possible. And we serve any disability with our organization's trust. We're one of more than 660 state and local chapters, as I mentioned, and we're the world's largest community-based organization of and for people with IDD. Our chapter has been in existence for over 58 years. This is our special needs trust team. So you see the picture of me and then my staff. We have another staff on board. Karen's not in the picture. And to the right, KeyBank, those are my primary contacts at KeyBank, though my staff work with different people at the bank because it has to do more with reconciliation and disbursements, etc. And along the bottom is the foundation of the ARC of Northern Virginia. The foundation of the ARC of Northern Virginia is a separate nonprofit that oversees the Special Needs Trust Program. I report to them, and they also oversee the endowment. So what is futures planning? It's a long, it's a process that is ongoing, and you address a long-term disability. These pictures of the pie are all the same size, but that doesn't necessarily reflect in real life, because some things at different times of someone's lifetime are more urgent and there's more and a greater need. But these are all the areas as we're planning for our adult children and adult children, and planning their lives with them, hopefully. These are the different areas that we need to address. So today in the presentation, I'll briefly go over letter of intent, legal authority, government benefits, estate planning tools, special needs trust in particular, and ABLE accounts. Each of these topics actually has a 2-hour presentation as well. So right now I'm just going to give you a briefing. So the first thing is a letter of intent. This is a guidance document usually written by the parents of children with disabilities or the primary caregivers that talks about that person, who they are, what they like, what they dislike. It talks about the past, the present, and the future. And since it's a guidance document, it may be changed at any given time because life happens and things happen and changes may need to be made. especially as the individual with disabilities ages. Some people with small children say, well, why would I even need to write this? Well, we never know what's going to happen. And all of this planning is just that. It's putting things in place, hoping for the best, but preparing for the worst. And so if something were, God forbid, to happen to me tomorrow, people at the Arc of Northern Virginia, my siblings, could pick up the letter of intent and read what my thoughts were for the life of my child, as well as, or my children, as well as what their likes and intentions are. The second area is legal authority, and this is the person with disabilities that we're talking about right now. So supported decision-making strategies, and this list goes from the least restrictive to the most restrictive. So supported decision-making is what we do every day. Putting on an outfit and turning to another person and saying, does this look good on me, or should I wear the white blouse instead? Right? That's supported decision making. And it's us teaching our children every day to make decisions as well. Because the more we help and assist them in decision making, right, not making the decisions for them, but teaching them how to decision make, the better prepared they will be to make their own decisions in life. Authorized representative for Medicaid. If anyone has a child or a person they're caring for that receives Medicaid, Medicaid waiver included, then usually there's an authorized representative in place, in particular when the person is not able to handle setting up the meeting, signing the paperwork, and understanding all of the documents. If the recipient of Social Security is unable to manage their own funds, then a representative payee would be put in place. And next is power of attorney. Now, power of attorney, these are legal documents, and someone becomes the agent on that power of attorney. So I have power of attorney for both of my children, both financial power of a durable, not adorable, but DURABLE power of attorney for finances, and a health proxy as well. So I'm their agent. I've set up successor agents in the document. And in the health proxy, there's also the advanced medical directive. And we've seen more and more of these lately, especially because of COVID. The advanced medical directive, as you may know, is that document that says, keep me alive at all costs, or after 5 tries, do not resuscitate, or do not resuscitate, period. I will try experimental drugs if there's something that is out there and research is being done, etc. On the Disability Law Center in Virginia, and every state has one of these, there is actually on the Virginia site under resources supported decision making, a advanced medical directive and a health proxy written by their attorneys that you can actually use for you as well as for your children. The next step along the pathway potentially would be guardianship. So guardianship is of the person and conservatorship is of the finances. Guardianship is when you strip a person of their civil rights, and primarily during the legal process, where in Virginia, an attorney is often hired, though you can go pro se, you can do it on your own. They're looking at the right to vote, carry firearms, choose whom they wish to marry, where they wish to live, sign contracts, and to drive. Those are the 6 primary areas that are looked at during guardianship. Someone could choose limited guardianship. They can vote, choose where they want to live and who they'd like to marry, but they may not carry firearms, drive, or sign contracts. That would be limited, for example. So you could pick and choose. Someone could potentially have limited guardianship and a power of attorney, because if they didn't select some areas of that guardianship, those are open to powers of attorney. The guardianship is saying the person is incapacitated in specific areas. And when one petitions for guardianship, the court assigns a guardian ad litem, which is oftentimes in our area an attorney, to the individual with disabilities. And that GAL, G-A-L, guardian ad litem, is to speak with the person and find out, are they indeed incapacitated or not? And evidence needs to be presented on both sides, documentation, medical records, etc. And then the judge makes a decision. There's a court order, and that is legally binding until someone goes back to court to ask to change it. A lot of times with guardianship, you want to name a standby guardian. So mom and dad are the guardians, and the standby guardian is sibling X, right? And that could be in the, that way you don't have to go to court again to add that person. Although when the parents are no longer able or willing to function as guardians, that standby guardian would need to go into court within 60 days and say, here I am, and I will be the new guardian. Conservatorship, as mentioned, is of the finances. So the court usually does not entertain conservatorship if the individual has less than $2,000 in their name. And that $2,000 is that asset limit on means tested benefits like supplemental security income and Medicaid. So someone may have conservatorship, full conservatorship, but someone may also petition the court for limited conservatorship. Joe's 37 years old and all is going well. And then all of a sudden, Joe inherits $80,000, and that needs to go into a special needs, first party special needs trust in order for Joe to maintain the Medicaid waiver and other means tested benefits. Well, Joe can't do it on his own because there's a guardian, but the money needs to be moved, and the guardian really does not have the authority to transfer those funds. So a limited conservatorship may need to be put into place to transfer those funds, and then it would end after the funds were transferred into the trust. So again, it goes from non-restrictive to restrictive, and it's based on need. At any given time, somebody can come in and take on one of these roles. A lot of times the first 5 are done when the individual turns 18 or thereafter. If you need to get an educational power of attorney, that can actually be done 3 months before the individual turns 18. Next, means tested benefits. So when we talk about means tested benefits, we're talking about Medicaid, home and community-based Medicaid waivers, supplemental security income, and other benefits. So what is Medicaid? It's a joint federal and state program authorized under Title 19 of the Social Security Act. So Medicaid falls under the Social Security Act that provides health and long-term care coverage for specific groups of people with low income. All right, it's a joint federal and state program. State plan Medicaid. So that's health insurance for people that have children and their low income families, for pregnant women, for the elderly, for persons with disabilities, and parents meeting specific income thresholds. Right? That's health insurance paid for by Medicaid. The other form of Medicaid is the home and community-based services, which are Medicaid waivers. You hear that term Medicaid waivers more than you hear HCBS, home and community-based services. It's state specific. So not every state has Medicaid waivers, right? Not every state has Medicaid waivers. And if your child, and I say child meaning they could be 2 or 22 or 52, whatever the age, if they have a Medicaid waiver and they move, not you, it doesn't matter where you are, but if they move to another state, they'll lose the waiver, say from Virginia, if they then move to Maryland, and in Maryland would have to go through the waiver process there. So these waivers are long-term care waivers. So it's the health insurance under Medicaid and then some. In Virginia, there's eligibility criteria, which is functional, financial, and diagnostic. So there's specific criteria that must be met. This is the $2,000 threshold on the waivers and on the Medicaid in general. And it's important to keep that amount under 2,000, otherwise you jeopardize those means tested benefits, because they're looking With the Medicaid state plan, they're looking at the family's assets and resources if the individual is under 18 when it's a disability, or the family in general in those scenarios. When it's a Medicaid waiver, they're looking at the individual with disabilities, assets and resources. So there's a difference between the two, okay? So a child could have a Medicaid waiver in Virginia as long as they have less than 2,000 in their name, then the parents may be very wealthy, but they're looking at the child's assets. Whereas the state plan Medicaid, they're looking at the family. Another means tested benefit is supplemental security income, which is from Social Security Administration. And SSI is based on financial need. And it's for people in that similar category that have little or no income. And it helps to provide cash for basic food and shelter. So it's primarily meant for food and shelter. There's also functional criteria and diagnostic criteria. So again, generally speaking, the earliest we apply for supplemental security income is when the individual is 18 years and 1 month, 18 years and 1 month old. And they look at that person's financial resources. They must have less than 2,000 in their name. If they have more than 2,000 in their name, and you have to report everything, if there's more than 2,000, then they're denied Social Security benefits on a technicality, they call it. So that simply they're over-resourced. And so Social Security doesn't look at the rest of the application because they look at the financial part first. So back with Medicaid, I'm the authorized representative for each of my daughter's Medicaid waivers. My girls are 21 and 26. So they can sign their documents and I can as well. With the SSI, I'm their representative payee. They are unable to manage money. And so I am responsible for making sure that money is managed well. And in 2021, so as of January 2021, the SSI dollar amount is $794 a month. So it went up a little bit. And primarily, again, for room and board. And after those needs have been met, it can be used for other things. That question is asked a lot, so it may be used for other things. Other means tested benefits with other financial thresholds, right? The other things, the Medicaid, the supplemental security income, those had $2,000 thresholds. The waiver's a little bit higher, but we say 2,000 to keep it simple. The other means tested HUD, which is the housing vouchers, they have a $34,000 threshold. SNAP, which are the food stamps, Supplemental Nutrition Assistance Program, they look at the family, or if the individual is living with the family, then the individual has to be, excuse me, has to have their own food, shopping, cooking, and whatnot. You have to say that their eating is completely separate from yours in order for them to potentially be eligible for food stamps. Legal aid is on a sliding scale. And then utility and energy assistance is also offered in the summer and in the winter. So when it's super hot or super cold. And if anyone still gets paper copies of their bills, if you flip it over on the back, they'll explain that energy and utility assistance there. Estate planning and other considerations. So this is you now. We're talking about the parents. You need to get your estate in order sooner than later. See, people say, even when I have a small child, as I mentioned before, yes, you want to do this sooner than later. The girl's dad and I knew nothing about anything back in the day. And I remember I was working for a nonprofit. This was in Naples, Florida. So it was a good 16 years ago, I think. I don't even remember. And I was approached by one of the attorneys who said, you need to have your wills and your powers of attorney, et cetera. And we said, okay, we'll do it. So everything on that list that you see there, last will and testament, powers of attorney, advanced medical directive, and special needs trust, she prepared for us at the stunning price of $720 for everything, everybody, which is half of what a and attorney charges by the hour in Northern Virginia. But anyway, the she did all of those documents for us, and we didn't know what a special needs trust was. I'm sure she explained it to us, but we couldn't remember. But we each had our will done, so you should have a will. In that will, it tells how your estate will be divided upon your passing. Now, if you're married, your spouse, unless otherwise, your spouse gets everything, and when the second to die in the marriage passes away, that's when everything gets divided up. But everybody has their own individual will. Powers of attorney for us as well. Again, financial and health are very important. So after my divorce, I asked a very good friend of mine, and she said yes, she'd be the power of attorney. And again, I set up successor powers of attorney in there. So they're agents. They have no authority. If I'm able and willing to talk and make decisions and do what needs to be done, then I'm doing that. But that document gives them the authority, like when I was in the hospital, for my friend Maureen to come in and go and talk to the doctors on my behalf and have information shared. Right? That was super important. And the Advanced Medical Directive is there as well. And then the special needs trust to get established in order to direct your money to a vehicle, a legal vehicle, to direct any assets and resources you have to a legal vehicle that's going to protect those assets and resources and be for the benefit of the person with disabilities. Once you've taken care of the legal documents, you need to go back and look at beneficiary designations. So, how am I going to fund the trust? Well, through my last will and testament. So it says 50% to Sky's Trust, 50% to Sheridan's, actually using more legal terminology. And then the life insurance policy, I've designated each of the girls' trusts as well. So after the trusts were established, so by the way, we established those trusts, and when we moved to Northern Virginia and knew the ARC was managing trusts, we established trusts with the ARC of Northern Virginia and revoked the trusts that were originally established by the attorney. So I had to go back and change the beneficiary designations and reflect the new trusts for each of the girls. If you're military and have a survivor benefit, that can be irrevocably assigned to a first party trust. So you may choose spouse, child, or child. And when the child has a long term disability, they will receive your survivor benefits. Adult child support at 18, even if the money's going into the spouse's, one of the parents' bank accounts, at 18, it is deemed the individual with disabilities money. So if you are divorced or are divorcing, then you want to make sure that the child support is irrevocably assigned to a first party trust. And then you establish that first party trust, both for the military SPP and the adult child support. If you don't, that money is considered unearned income for the person, and it will definitely affect any supplemental security income, since it's reportable to Social Security that the person has this unearned income. But when it's assigned irrevocably to the first party trust, it does not count. And then housing options. That's a huge consideration to make. And I think one of the most important ones, once after all of those things are done, the first seven, and then you start thinking about housing. When I'm dead and gone, or beforehand, hopefully, where will my adult children be living? And what situation have I put into place? Because I want to make sure that they are safe and housed with a roof over their head and food on the table. If they have a job as well, great. But number one, I want to make sure they have a home to live in. So, what is a special needs trust? It's a legal vehicle that provides benefit to and protects the assets of a person with disabilities and still allows that person to qualify for and receive government benefits. So, it's a legal vehicle and it benefits the individual with disabilities. It protects any assets that you're leaving to them or they may get outside of that third party trust, and they're still able to qualify for and receive their Medicaid, for example, Medicaid waiver, subsidized housing. And by the way, if you have questions, please put them in the chat box and we'll be answering those questions at the end of the slides. So who's eligible for a special needs trust? Well, Social Security defines it as anyone with a physical, mental, and or developmental disability. So very broad. And our special needs trust program says the same thing. Anyone with a physical, mental, or developmental cognitive disability. Very broad. Why do people establish it? The number one reason is to protect any government benefits they have. So I want to be sure to protect my daughter's Medicaid waivers, because those waivers provide more than just a health insurance. Remember, it's long-term care. So there's a job coach, there's housing, there's assistive technology, environmental modifications, there's transportation, there's a whole long list of potential benefits, potential activities, potential services that Medicaid waiver provides and that Medicaid pays for. Without that waiver, they would be living with me until I died, and then who knows where they would go, right? I'd have to have some backup plan and hopefully have saved enough money to pay for all those things. But by protecting that Medicaid waiver and their supplemental security income, I know that there's going to be something in place for them long term. It's also meant to help people with money management and long-term financial planning, because we have many trusts where the individuals they do not have SSI or Medicaid waivers. They may have Social Security disability insurance and Medicare, which are entitlements, but their parents know that if they left a chunk of money to them, they would not be able to manage it. The money would be spent either by the individual or the individual's new best friends who'd come along magically once they found out there was money there. And individuals with disabilities, if they're setting up trusts, their own trusts, which they can do because they've come into a lump sum of money, it's also because they realize that they cannot manage that money. And lastly, but not necessarily in third place, it's meant to promote the dignity, comfort, and happiness of the person with disabilities. Government benefits provide the basic, right? Room and board, clothing, health insurance, transportation, for example. But for those better things in life, that's what the trust is meant for. It's meant to supplement. I presented to a group at another ARC years ago, one of my first presentations, and the group were elderly parents, and their adult children were all being taken care of through the group homes at that ARC. This was in Maryland. And they said to me, well, why do we need a trust? Why do they even need any money? And I said, how many of you see your children? And well, of course we see our children. Okay, what do you do? Well, we go bowling once a week. We go out to dinner on Friday nights. We go to the movies when a new movie comes up. Great. Who's paying for that? Well, I am. All the parents are saying they're paying for it. And then I said, who's going to pay for it when you're dead? Very blunt, I know, and they all just looked at me. And I said, that's why you have a special needs trust, because the government benefits don't cover all of those quality of life expenses, right? They're not paying for vacations. Maybe there's a little vacation, but they're not paying for a week-long vacation in Disneyland or a nice Nike pair of tennis shoes for God knows $180 or what they go for now for men in particular. That doesn't cover those things. It's a jacket from Walmart, a sweater from Target, right? Which are fine, perfectly fine, but it's not for dental. It's not for, the government isn't paying for funeral burial. The government isn't paying health insurance premiums on a private health insurance. It may not pay for specific therapies that the person wants. So that trust is there to promote the dignity and supplement what the government isn't paying for. So what is a trust? I'm going to play this video and let me know. Hopefully, if you can't hear it, let me know. I'm going to assume that you can. Let me go in here.
Families of people with disabilities often use trusts to set aside money for the future. A trust is a special legal arrangement that puts a trusted person, a trustee, in charge of managing money for someone else, a beneficiary. A beneficiary can be anyone who has a hard time handling money themselves. In a special needs trust, the beneficiary is someone with a disability. Here's how the process usually works. In most trusts, a grantor, usually a family member, sets aside money, property, investments, or other assets for the beneficiary. The grantor chooses a trustee to manage the assets for the benefit of the beneficiary. The beneficiary has no direct control over the assets and can't spend them. That's the role of the trustee. The beneficiary's needs and desires are taken into account, but the trustee has the final say over how the money is spent. And that's what makes a special needs trust so valuable.
Somebody that is on means-based public benefits can only have $2,000 or less in assets. If they have more than $2,000 in assets, they're going to be bumped off of those public benefits, and that's not a good thing.
Even though the beneficiary doesn't control the assets in a special needs trust, day-to-day, month-to-month spending decisions by the trustee can affect benefits if they violate any of the rules, laws, and policies that apply to benefits. That is where the ARC of Northern Virginia can play a crucial role.
The greatest strengths of the ARC of Northern Virginia is their experience and their expertise in the special needs arena. They're not going to make a mistake in a distribution and bump somebody off of public benefits. The rules in special needs area change constantly, and somebody that is not familiar enough with the special needs arena is not going to be able to keep up to date on those rules.
And that's one reason why more than 1,000 families have decided to entrust those tasks to the ARC of Northern Virginia and our partner, Key Bank. In our trusts, we divide the responsibilities of a trustee in two, adding the role of manager to the mix. ARC team members are experts on day-to-day trust spending decisions. Key Bank's team are experts at managing and growing the money in a trust. Adding the ARC team as manager makes everyone's role easier and adds another level of confidence to the future of the beneficiary with special needs. There are a lot of things trust money can be used for, but there are things it can't be used for. Having experts at the ARC overseeing spending decisions takes a big burden off the family of a beneficiary.
It was very overwhelming to me to realize that I needed to all of a sudden learn about Medicaid, Social Security, Special Needs Trust. Who had even heard of that?
It is impossible to think of all the future needs of your family member. And this offers a sense of security for those who support that family member.
The ARC of Northern Virginia's Special Needs Trust team works closely with Key Bank staff to make sure the planning, setup, funding, and operation of every trust runs smoothly. We'd love to talk to you about setting up a trust for you or a loved one with a disability. We serve people in Virginia, Maryland, Washington, D.C., and areas beyond. Our trust program is open to people with any disability. Here's how to get in touch.
Okay. So that was a introduction to the trust program that we have. So who's who in a special needs trust? Well, anytime you have a trust, you have a trustee, right? And a trustee has a fiduciary responsibility. So they're responsible for asset management, asset allocation, account reporting, tax reporting, check writing, dispersing, transfers, however the money's getting out, right? So you have to have a trustee because they have that fiduciary responsibility. At the ARC, we have Key Bank, who's our partner. Key Bank is a bank out of Ohio and New York, and they have the fiduciary responsibility. You never have to worry about successor trustees because Key Bank is the trustee. If they chose to leave us or we ask them to leave, there's a document, we have legal and binding agreements, and then we would find a new trustee. So you never have to worry about succession. If you go to an attorney or a financial institution, then you, the parent or parents, for example, are the trustees or co-trustees. And you need to name successor trustees. Now, with a bank, the bank could simply take over when you no longer are able or willing to function. But generally, you would want to have a co-trustee along with them as well. So a lot of times, parents have put that burden on the siblings of the people with disabilities to be those successor trustees, and a successor trustee along with the bank to manage the trust. At the ARC, we are the manager. So Key Bank and the ARC of Northern Virginia work together. We collaborate in managing the trust, overseeing it, administering it, making sure all the rules and regulations are followed, both banking regulations and disability regulations, whether it's Medicaid, Social Security, housing, etc. Through an attorney or financial institution, there's not a manager, right? That's the trustee's job. The ARC, you have the grantors. Those are the people establishing the trust. You may or may not have a grantor at the through a trust with an attorney or financial institution. You may or may not. It could be there because the trustee and the grantor could potentially be different people. There's always a beneficiary, right? That's the person benefiting from the special needs trust, no matter where it's established. On our trust document, we ask for primary representatives, and I'll make that a plural the next time. So the primary representatives are the people, our primary points of contact. They can ask us questions about the trust. We can ask them questions about the individual or situations. And you always want to name, whenever possible, we'd rather have more names than only a few. And that's because people die. And we've seen it happen where we've gone through 6 to 8 primary representatives. Thank heavens, both of those families had a long list of people that we could contact. With an attorney or financial institution, when establishing the trust, the attorney may recommend adding a trust advocate or a committee to take on a similar role to a primary representative. So it's a go-to person or a go-to group of people. But we find that they're very important because you want to have continuity. So this is where, whenever you have a trust with the ARC of Northern Virginia, siblings to the people with disabilities are often named. And if there are no siblings, or if the siblings are estranged, you can name organizations, program manager at the group home, or current therapist, or current milkman, whatever it is, whomever you trust and choose, you name a title of a person as opposed to an actual person. And we see that in some of our trusts as well. Knowing that those primary representatives, when they come to us, we have the final say in whether or not we're going to disperse, just like the trustee on the trust with the attorney or financial institution has that final authority. We always ask in our documents about legal authority because we need to know who's responsible for what, right? And then we get copies of those documents. That's not in your special needs trust through an attorney or financial institution. And then remaindermen, that's who inherits whenever the beneficiary dies. So you always are determining who's going to inherit. So our partnership with Key Bank, what you see here is if you had a private trust, I call it a private trust, if you had a trust through an attorney or financial institution, this is what those trustees would be doing, right? That's their job. With the ARC of Northern Virginia, we divide it up into 2 categories, basically, of the person and of the finances. And so we're there to provide services for people with disabilities. We have an understanding of current benefits, eligibility requirements. We follow the grantor's wishes. So how do you want those funds spent? We consider the beneficiary's needs and priorities. We're in a unique position in that we're a nonprofit advocating for the human rights of people with disabilities first. That's the premise on which we work. We want to do what's right for that individual with disabilities. Other nonprofits that are set up and authorized to manage trusts in our region are simply do that. That's their core job, is to do that. Whereas we have a mission statement and core values and core principles. And then we have a progressive fee schedule for accounts over $1 million, so for those larger accounts. And we'll talk about that later. And Key Bank, as any trustee, the first 5 bulleted things are what any trustee does: the asset allocation, asset management. How's the money going to be invested? And let's watch that money. The account reporting. So if somebody has supplemental security income or Medicaid, every month you get a hard copy bank statement. So if Medicaid comes back and asks for an account reporting, you'll have those documents. You should be saving them, at least scanning them and saving them if you don't want to keep the hard copies. If you don't keep them, we do have access to them. Tax reporting, there's annual tax reporting that Key Bank handles, the K1s. Check writing and dispersing, like I said, ACH transfers, however, we're moving the money out of the trust to pay for services, to reimburse people, etc. With Key Bank, if the investment is over $250,000 eventually down the road, you would speak to our financial advisor, which anyone may do at any given time, and that's free. And if it's customized, then there needs to be a conversation. So let's say your money is invested at Vanguard, and when you die, you want to transfer those assets to the ARC Special Needs Trust Program for your individual. One moment. Sorry. Then there's a conversation on doing that, because the Key Bank can take commonly traded stocks, there's bonds, there's things like that that can be transferred as is, whether it's under or over 250,000, but over 250, you may customize your investments, and you don't then have to choose one of the portfolios that are offered. Our trust program can hold real property, whether it's rental or the person is living in it. There's mineral rights, so anything on the ground or below the ground. And then, as I mentioned, in-kind transfers of stock. So there are 2 types of trusts. We saw about, there's third-party special needs trusts. We saw a little video there. Those trusts are funded or unfunded, meaning you establish the trust and maybe you put money in it now, maybe you put money in it 5 years from now when grandma dies, or maybe you don't fund it until both of you are deceased. That's your choice. You can establish it with an attorney or attorney or financial institution, or through a nonprofit like the ARC. First party trusts are usually established because they're going to be funded. And again, either privately or through a pooled trust program like the ARC of Northern Virginia. So what is a third party or family funded trust? It's a special needs trust, and there are certain things, right? Who establishes the family funded trust? Either the parents, relatives, friends, not the beneficiary. It's never the beneficiary who establishes the family funded trust. How is it funded? Through an inheritance. So in my last will and testament, remember I said 50% disguised trust, 50% to Sheridan's. Same with the life insurance policy that I have. You could have your own revocable trust, and in that trust determine how your assets and resources in your trust will be divided upon your death or at whatever given time. It could be contributions from that you wanted to put money in, or like I said, when grandma passes away, she could be contributing to it, real property, etc. It's not the beneficiary's money. So family funded, anybody but the beneficiary establishes it, anybody but the beneficiary may contribute to it. They're usually funded second to die when both parents are deceased, but they could be funded prior to death with seed money, just a low amount or more. What happens to the funds at the death of the beneficiary? So on a family funded trust, you, the grantor, is establishing the trust, or if you're the trustees on a private trust, you determine who will inherit the money in that special needs trust when the beneficiary is deceased. So again, Sheridan and Sky, whomever passes away first, her assets and trust will go to her sister's trust. And then when they're both deceased, I've determined who will inherit. What's the process? If you wish to establish a trust, you contact with the ARC of Northern Virginia, you contact us, Or if you're writing it with an attorney, you contact the attorney and we can refer you to knowledgeable elder law attorneys or a bank. So those are the places to go to establish it.
Many families set up a
Sorry, my bad.
special needs trust for a loved one with a disability. That's because a special needs trust does genuinely valuable things that no other structure can do. It provides for a trusted person to manage money and other assets for someone with a disability. It helps maintain eligibility for government benefits based on financial assets. It provides money for things that government benefits don't cover. It helps ensure long-term financial stability after parents can no longer provide care. All special needs trusts come with these benefits built in. Setting up a family-funded special needs trust with the ARC of Northern Virginia comes with additional benefits that our client families love.
We searched around and there really wasn't any other organization that could manage the trust, manage the special needs trust, and help us navigate through the process and help Brandon become more independent.
When I met the people in ARC, I really trust them. They are just really nice people, and they are the people you can trust. And ARC is a nonprofit organization who has a long history of helping people with disability.
I want somebody who understands the person I love and will help them manage that money in an effective way and really ensure that they're maximizing their public and private benefits.
A family-funded trust is a legal arrangement that allows family members, friends, and others to set aside money and other assets for the benefit of someone with a disability. That person, the beneficiary, is the only person who cannot contribute to the trust. A trusted person, a trustee, manages the money for the beneficiary. As a result, the trust funds are not controlled by the beneficiary. That's why the amount of assets in a special needs trust does not affect eligibility for government benefits based on assets. Even before the trust is created, a critical decision is choosing someone to manage it. It's complicated, tricky, and time-consuming. Our solution is to split the duties of a trustee in two. Our team at the ARC of Northern Virginia takes on the role of manager, handling day-to-day spending decisions. Our partner Key Bank serves as trustee, minding checks and bill paying, as well as long-term investing. It's a powerful combination, and all of our more than 1,700 special needs trusts are set up with the ARC as manager and Key Bank as trustee. Having two sets of professionals on your side pays off from day one.
I met people in ARC of Northern Virginia. They just showed me how capable they are and how I can trust them and the experience they have. It just made me make the decision that they are the one I'm going to use as the trust manager.
We looked at other organizations to do a special needs trust, and we just didn't feel like they had the body of knowledge that the ARC had.
We'd love to talk to you about setting up a trust for you or a loved one with a disability. We serve people in Virginia, Maryland, Washington, D.C., and areas beyond. Our trust program is open to people with any disability. Here's how to get in touch.
Okay. Oops. All right, so that's the third party. So now this is the first party special needs trust or the self-funded special needs trust. This is different. You'll see this is different from the third party. So remember the third party who establishes it, how to fund it, when to fund it, same areas covered, but who establishes the first party trust? Federal statute says it's the individual with disabilities, the parent, grandparent, guardian with a capital G. It may be court ordered or an agent under power of attorney. So that would be a financial power of attorney, usually that has the authority to do so. How is it funded? It's funded by an unexpected inheritance. So we have, for example, an elderly parent passes away, 97 years old, didn't realize that special needs trusts existed and just left the money directly to the individual. That's an unexpected inheritance. It was not designated to a third party trust, right? It should have been designated to a family funded trust. It was not. And so that money is the individual's money and it must go into a first party trust. A lump sum payback from Social Security could go into a first party trust. So, for example, you apply for adult disability through Social Security Administration, and it takes them 10 months to make a decision. Or sometimes if you appeal and it takes them 2 years and you win the appeal, and there may be a lump sum payback that's 24 times that 700 and some dollars. And that then when they get that lump sum, it puts them over the threshold of the $2,000. So that would go into a first party trust as well. A settlement, you're in a car, the person is in a car accident, the individual becomes disabled through the car accident or was already disabled, but wins, it has a settlement, that would go into a first party trust. Income, the person's earnings may go into a first party trust, as well as adult child support, military survivor benefit, alimony from an individual with disabilities, lottery. So anything that when it's the person's, the beneficiary's money. All right. So the self-funded trust is for the beneficiary's money. You only set it up when you have to. When you need to apply for benefits for that individual or that individual already has means tested benefits and doesn't want to lose them. Again, with the SBP, the survivor benefit, that's done before the parent passes away. So what happens to the funds at the death of the beneficiary? Well, either there's a Medicaid payback, meaning the person has had Medicaid and Medicaid keeps a track of how much the insurance has paid throughout that person's lifetime. And whenever the person passes away, and again, this is only self-funded trusts. When the person passes away, we send the death certificate to Medicaid, whatever state they've ever received Medicaid, and then they write back and say the Medicaid lien is $127,642.87. It's down to the penny. So if you selected Medicaid payback and then to the heirs of the estate, and the lien was 180 whatever $1,000 I said, and there was 2,000 in the trust, that goes to Medicaid. On the other hand, if you choose to leave it to the foundation of the Arc of Northern Virginia, Medicaid does not get the money and it comes to the Arc as a charitable contribution to help sustain the program. And so that's why there are two special needs trusts: family funded trust for family money, self-funded trust for the individual's money. Family funded trust, you determine who inherits. Self-funded trust, Medicaid payback, or the nonprofit managing that trust. And it's the same process. Either contact the Arc of Northern Virginia, since we serve all of Virginia, Maryland, and DC and beyond, or the bank. Now, this is the self-funded video. There's a little bit of repetition you'll see towards the end, but I want you to just have a good visual so you can remember what's what.
Unexpected income sounds like good news, and it can be. But sometimes, if someone with a disability gets a sum of money unexpectedly, that windfall could end up being a real problem. Here's why. Some disability benefits programs have an asset limit of $2,000. Having unexpected money come your way could also mean suddenly having more money than a program allows, and that could reduce or interrupt benefits. And even if government benefits aren't a factor, there's a risk the money could be misspent by someone who doesn't manage money well. Either way, unexpected money can be preserved and protected. A self-funded special needs trust with the Arc of Northern Virginia is an effective way to be ready for the unexpected and to have a solid plan for the future. We're experts at managing special needs trusts, and that's why more than 1,700 individuals have their special needs trusts with us.
The greatest strengths of the Arc of Northern Virginia is their experience and their expertise in the special needs arena. They're not going to make a mistake in a distribution and bump somebody off of public benefits.
I think the biggest value that we see as having ARC as the manager is the fact that they really understand all the different needs that Brandon might have. And I think that was huge for us.
Here are some basics. A special needs trust is a legal arrangement that sets aside assets for a beneficiary, someone with a disability. A trusted person, a trustee, manages the money for the beneficiary with a disability. As a result, the amount of money in a trust does not affect someone's eligibility for benefits with asset limits. A self-funded trust is called for when assets are in the name of the person with special needs. The assets might come from an unexpected inheritance or a legal settlement, such as a personal injury award. It could be child support for someone who has turned 18. It could be spousal support after a divorce. Sometimes money comes from the U.S. Military Survivor Benefit Program, or as a lump sum payment of Social Security benefits. And of course, you could win the lottery. There are several people who can set one up. The beneficiary himself or herself, their parents or grandparents, or a guardian can do this. Someone with financial power of attorney for the beneficiary can do it too. At times, the court may order the creation of a self-funded trust. Even before the trust is created, a critical decision is choosing someone to manage it. It's complicated, tricky, and time-consuming. Our solution is to split the duties of a trustee in two. Our team at the ARC of Northern Virginia takes on the role of manager, handling day-to-day spending decisions. Our partner Key Bank serves as trustee, minding checks and bill paying, as well as long-term investing. It's a powerful combination, and all of our more than 1,700 special needs trusts are set up with the ARC as manager and Key Bank as trustee. Having two sets of professionals on your side pays off from day one.
The rules in special needs area change constantly, and somebody that is not familiar enough with the special needs arena is not going to be able to keep up to date on those rules.
It's a very complex process to go through, and when you're doing it on an emergency basis or when you're in a crisis, it's even more stressful.
We'd love to talk to you about setting up a trust for you or a loved one with.
Okay. So this is how our team supports our trust clients. There's pre-work being done, right? We help educate and plan with the family, prepare the trust work, paperwork, and facilitate the trust plan or letter of intent preparation. And Key Bank reviews and approves the trust documents. They'll troubleshoot special situations and ensure compliance. They'll also review your legal documents when you're a client of ours. And once it's funded, we review and process client disbursement requests, ensure that each disbursement aligns with the grantor's priorities and the beneficiary's needs, maintain up-to-date documents and trust plans, and coordinate with case managers and other stakeholders supporting the beneficiary. And Key Bank, they'll process the disbursements, distribute the statements, conduct reviews. So they're following all the banking regulations, tax and account reporting, investing, managing real estate. So again, what we do together as a team, when you have, or if you have a trust that you've established through an attorney, this is what your successor trustee will be doing. You don't have any work to do because usually the trust isn't funded while you're alive. It's the successor trustee that takes on the work that's listed here on this slide, whereas the ARC and Key Bank do it for you when the trust is with us. So you want to make sure that if you are taking the private route, that you put competent people in place and that you also give them an out. And that's usually in every trust document that says if the trustee is unable or unwilling to serve, then then they say what's to happen. You saw in the first slide, the two sisters, Ruth and Kate, their parents had made them successor trustees of the trusts, and they came to the ARC of Northern Virginia and decanted those trusts to our trust program because it was just too much for them to do. That's where we are today. We've established over 1,750 trusts with over 43 million under management. These are our fees. So to establish a trust with the ARC of Northern Virginia, there's a one-time enrollment fee of $1,050, 1050. And for a second trust for that same individual or their sibling, it's $525. buy one, get one half off at the ARC of Northern Virginia. We feel that we already have a client relationship with you, and so therefore we'll do half price trusts, same exact paperwork, et cetera, same amount of work, but we've already developed a relationship with you, which we value, and so we offer that at half price. And then on the first anniversary and every anniversary thereafter, for an unfunded trust, we would invoice you for $65. Or if you fund the account, and right now the minimum would be $300, that's considered seed money, like you're planting a seed, right? Then the annual management and trustee fee is 1.49%. So on $300, that's about $4.48, I believe. So that fee is what we charge in order to do all the work that we do that you saw on the previous slide there, right? And then some. Reconciliation, FedExing, troubleshooting problems, etc. And the only other fee is when the individual passes away or the trust is about to be depleted, there's a $250 charge. So a lot of times whenever it's a trust through an agency, like the ARC of Greater Prince William County or any other agencies we work with in our region here, we're not so concerned about that closing fee. It's just so you know that for my agency friends out there. So the only fees is to establish the trust, a one-time fee, and then either the $65 or the 1.49%, and then the closing fee. So we do not charge for phone calls. We do not charge for disbursements. We do not charge for the first consultation. If you want to see me multiple times, there is a fee to charge for that, but that's outside of trust administration, and that's why. But there's always the option to have one free 1-hour consultation with me as well as attending our Trust Talk Tuesdays that are twice a month and any of our First Fridays future planning topics. And we have the rest of the fiscal year planned out. So for February, it's going to be military benefits and financial planning for the military and planning for their retirement. I'm trying to see if I have my list handy. I can't remember, so don't quote me for March, but I know we have one coming up on special needs planning. Another one, we have one coming up on dispersing from the trust. March is actually financial planning. So we have a financial planner talking about ways to fund a special needs trust. March actually is divorcing and families with children. We'll also talk about the child support enforcement update. And then April is finding that sweet spot when planning for retirement. May is dispersing from your trust. And June is estate planning and legal documents. And all of these presentations, by the way, are also found on our website once we've completed them. So next topic is ABLE, and then we'll be able to take questions. So what is the ABLE Act? ABLE stands for Achieving a Better Life Experience, signed by President Barack Obama on December 19th, 2014. And it authorizes states to create a savings program for a new category of savings programs for people with disabilities. Like special needs trusts, the assets held in the account that comply with ABLE rules do not affect eligibility for Medicaid, supplemental security income, or subsidized housing. So a lot of times people have both an ABLE account and one or more special needs trusts, and we work together on dispersing from those different financial products. Although we do not oversee the ABLE accounts, that's something, if you create one, then you're responsible for managing it. The ABLEs are for qualified disability-related purposes, directly related to the disability, and it was originally meant to be a transactional account, so money in, money out, to empower the person with disabilities to have some oversight over their own money, and used as a savings mechanism. So it's there to complement a special needs trust. It's in addition to, as opposed to in place of establishing a trust. Here are some ABLE facts. So onset of disability The individual has to have been found disabled prior to the age of 26. Who may establish it? The beneficiary if they're when they're over 18, or the parent when the person is a minor, or if the parent becomes an 18 or older of the individual a guardian, or they're an agent under power of attorney. So it's also very specific as to who may establish it. The person may have one ABLE account. You can have 27 special needs trusts, but you may only have one ABLE account. Also with the special needs trust, it does not matter when the person became disabled. The fees are lower in comparison to special needs trusts, the financial institution fees, and they have also some management fees. There are contribution limits on the ABLE. There are no contribution limits on special needs trusts, but on the ABLE, it's a maximum of $15,000 per year based on the federal gift tax limit per year. And there's a cap based on the 529 plan. So Virginia, it's 500,000. Maryland, it's either 500,000 or 525,000. I can't remember. And then if an ABLE account were to have $100,000 in it, SSI would be suspended. That is not so with trusts, okay? The investment options, so with the ABLE accounts in our region, they usually have cash and then 3 investment strategies. With the Special Needs Trust Program, it's cash or 8 or more investment strategies with the ARC. Valid distributions, broadly defined as disability expenses, and there's another slide on that. Taxes, so the earned income is tax-free. That's different from a special needs trust. Earned income is taxable. The Medicaid payback in Virginia and Maryland has been removed now, so the state may not ask for a Medicaid payback. The federal law may request a Medicaid payback, so the feds could always ask for a payback though. And then if the individual is earning money, in addition to that $15,000 that anybody may contribute, and that it's capped at $15,000 a year, if the person is working, they may contribute up to an additional $12,490. It's a little bit higher for 2021 of gross income if they're not contributing to their employer's retirement plan, employer-sponsored retirement plan. So if they've signed up for a 401k or a 403b or whatever with their employer, they may not contribute that 12,000 plus. Okay, it's still counted as income, anything that goes in there from the person's income. So ABLE is meant for qualified disability expenses directly related to the disability and for the benefit of the designated beneficiary. So the Family Funded Special Needs Trust has the broadest use of the funds. It can pay for anything on this list and then some, because it can also be used to buy gifts for other family members or friends or whatnot on the Family Funded Trust. The Self-Funded Trust, you cannot buy gifts for other people, but it has a very broad use of the funds. It does not have to be a disability-related expense either. The ABLE is the only one that must have the expense being directly related to the disability. These are the categories, but it has to be a disability-related expense. So, employment training and support. If everybody at the job site is getting the same training and they have to pay for it, that really isn't something that the ABLE would pay for. But if it's specific to the person's disability, then the ABLE could pay for that. The trust could pay for it no matter what. Now, what the ABLE does have, in addition to the tax, no taxation on the returns, is that for each person that contributes the first $2,000 into an ABLE account annually, they're able to write that off on their taxes. And the loophole, I call it, although I'm sure that's not the correct legal terminology, housing and food expenses when related to the disability, the food expenses, and housing, you can use the ABLE account and you don't have to report that housing expense to Social Security. And that goes, I'm getting into the weeds, but that's a good thing about the ABLE as well. So we have clients that we've recommended they open ABLE accounts so that we can transfer their rent money from the trust to the ABLE, because they're on SSI, the trust to the ABLE, and then have the ABLE account pay the rent. So qualified disability expenses and ABLE, the IRS. So whatever financial institution is overseeing the ABLE, where you've signed up for an account, has to provide annual tax reporting to the IRS, just like with the trusts. The IRS may investigate distributions from the ABLE account to determine whether a withdrawal was for a qualified disability expense. This is not so for special needs trusts. This is only specific to ABLE. And if the ABLE funds were spent on non-eligible expenses, you have to pay taxes on the growth plus a 10% penalty on those earnings. So the fee may be, the penalty may be minimal. Any non-qualified withdrawals are considered income for that month and could count against eligibility for SSI benefits or Medicaid. So again, you need to know how you're dispersing. Just like if you're overseeing a special needs trust, you also need to understand when dispersing from an ABLE account or transferring funds on the ABLE that you're not jeopardizing any benefits that the person has, and that you're handling the money correctly, which we all want to see happen for any accounts that any of us have. The financial institution sends a monthly report to Social Security Administration. And if the person is receiving supplemental security income, Medicaid, housing, those state and federal agencies may investigate any distribution to determine whether the withdrawal was for a qualified disability expense. So with the special needs trusts, SSI, Medicaid, and HUD, for example, may also come back to look at disbursements, okay? And we always strongly recommend, and as do the ABLE websites, recommend keeping good records, including receipts in case you're audited. And that's why when you disperse from a trust with the ARC, we too want a copy of a receipt, an invoice, or bill. So it's really important to keep your ducks in a row. This is a quick summary of our strengths. We're in a unique position, being part of a national organization that advocates for the human rights of people with disabilities. We're experts on current disability regulations through trainings and conferences and meetings and etc. There's minimal family responsibility when managed with the trusts with the ARC. There are multiple checks and balances, 2 sets in-house, and then it goes to KeyBank, who also checks. Low fees. The seed money, the minimum is only $300 if you wish to fund it. The account reporting and tax reporting is done by KeyBank. Multiple investment options, as well as customized investments. We can hold real property and handle in-kind transfers of assets and resources. So it's time for questions. There's my slide at the end. So the slides are going to be posted. I'm going to stop sharing and come up on the screen, full screen here. And I'm going to actually not do that. Now that I think about it, okay, let me go back to sharing screen because we do not want everyone's information on the screen. And Kayla will have to edit that later. So we'll go back to this, and then I'm going to look at the chat. We only have 2 things in the chat. Oh my gosh, somebody said they cannot hear, so I hope that was only one person. There are no questions, surprisingly. So if you have a question, write it in the chat for me now, or raise a hand and Kayla will be able to unmute you. But I don't want to put the screen up again because there are last names on that screen. Okay, so there are no questions. Amazing. So know that, as I mentioned, Trust Talk Tuesdays are available twice a month. You go to the arcofnovatrust.org website, and under events, the Trust Talk Tuesdays, you RSVP, and we invite you. And it's set up like this. It's a video conference with a gallery of people. I talk about special needs trusts. Each individual introduces themselves and then asks questions accordingly, whether it's trusts or Social Security or Medicaid waivers or moving to another state, or whether I find an attorney that can help me or a psychologist that can help my child. And the first Fridays, as I mentioned, it's the first Friday of the month, between same time as this, 10 to 12. And the different topics, the next one is on military benefits. And then one free 1-hour consultation with me is always available to you. And we're here to establish the Special Needs Trust and create the documents for you. So I want to thank the ARC of Greater Prince William County for inviting me to do this presentation today. And be well, stay well, everyone, and have a great weekend.